former civil servant ICS officer Mukhtar Masood, who later on went to Pakistan. दो इस किताब में जिना साहब की बहुत कसीदा आराई है और बहुत सारी बातें from the Pakistani perspective it has been written. But this book has two importance. It is one of the finest book of Urdu literature, and it mentions about AMU when Sarojini Naidu became the governor of Uttar Pradesh and she visited the AMU campus. और उसका उसमें पूरा जिक्र है उस किस्से का. सलमान साहब तो वीसी लॉज में उसी आसपास पैदा हुए हैं तो वो ज़्यादा बेहतर बताएंगे. उसमें उस किताब में आवाज़े दोस्त में एक जिक्र है. हम सब जानते हैं कि आर्नोल्ड टॉयनबी एक बहुत बड़े हिस्टोरियन रहे हैं जिन्होंने 12 वॉल्यूम में द वर्ल्ड ऑफ हिस्ट्री लिखी है. मुख्तार मसूद साहब को बड़ा इश्तियाक था, बड़ा शौक था कि मैं कभी आर्नोल्ड टॉयनबी से मुलाकात हो जाए मेरी, और इत्तेफाक से बहुत छोटे थे तो वो मुलाकात हो गई और उनको ऑटोग्राफ बुक लेकर हमेशा चलने का शौक हुआ करता था. तो ही प्रेजेंटेड इट बिफोर आर्नोल्ड टॉयनबी कि सर आप प्लीज़ मेरे लिए कुछ, जो अमूमन आम तौर पर होता है बिफोर दिस इंटरनेट एज, write something for me. And Arnold Toynbee very gladly wrote something. Now this is the important line. तो बहुत से लोग आप जानते हैं कि सिग्नेचर करने के बाद तारीख भी डालते हैं. तो आर्नोल्ड टॉयनबी ने अपना दस्तखत किया और तारीख नहीं डाला. He asked मुख्तार मसूद ही when he was young कि आज कितनी तारीख है. Of course हम सब जो अंग्रेजी तारीख होती है उसका जिक्र करते हैं, जैसे 1 फरवरी है. Toynbee said, नहीं, आई एम टॉकिंग अबाउट द इस्लामिक डेट. एंड मुख्तार मसूद को नहीं पता था. देन Toynbee said, जो कौमें अपनी तारीख याद नहीं रखती हैं वो कौमें ज़्यादा दिन तारीख में बनी नहीं रहती हैं. सो वाई दिस इज इम्पॉर्टेंट एजी नूरानी मेमोरियल लेक्चर कि हम इस तरह के प्रोग्राम करके अपनी विरासत, अपनी तारीख को बचाने की एक अदना सी, एक छोटी सी कोशिश करते हैं. But when we decided to have this, the greatest challenge was to have a speaker of that stature. And we are so happy that we got Dushyant Dave ji. शमामा ने इतनी बारी जिक्र कर दिया कि मैं कुछ नहीं कहूँगा, बट मैं सिर्फ एक जुमला कहूँगा. He was the person who said, Justice Chandrachud has done great disservice to the Constitution and I have sleepless nights thinking about it. एक सिटिंग चीफ जस्टिस ऑफ इंडिया के बारे में एक वकील अगर ऐसी कोई बात कह सकता है आज के ज़माने में तो वो दुष्यंत सवेद साहब जैसे कुछ ही लोग बचे हैं जो ये कह सकते हैं. So he is not only a senior advocate and 3 times president of the Supreme Court Bar Association. In my humble opinion, he is at present the conscience keeper of the Indian judiciary, the Constitution, and the Indian Republic at large. Thank you, Dushyant Dave sir. With these words, now I will request you to formally start your lecture. अमूमन एजी मेमोरियल लेक्चर्स में सवाल जवाब नहीं होते हैं, but we may break the tradition with the permission of the chair. After he finishes his talk, I would be very happy if you'd come out with some questions and he would be gladly answering. Thank you, sir. Thank you very much.
Good evening, everybody. Distinguished ladies and gentlemen, Mr. Salman Khurshid, an old friend at the bar, and someone who has never disappointed me. When I needed, when he was a minister, a family friend had come into a problem and I needed urgently a visa from a particular embassy. I just rang up Mr. Khurshid, and within no time Mr. Khurshid arranged the necessary visas through that embassy.
Sir, your mic. People will be able to hear.
Thank you.
Thank you, sir.
I also remember one day when I was actively involved with the international arbitration scene, and the International Council of Commercial Arbitration president suddenly decided to come to India, and I was hosting a impromptu dinner I rang up Mr. Khurshid. He was then law minister, and he readily accepted. And just 2 hours before, I think, the dinner, he came, and it became a lovely evening. The ICC president was very, very impressed by that. So Salman Bhai has been a good friend. Thank you for inviting me. Thank you, Mr. Iqbal Bhai, also. I see many young friends from the bar, therefore it's little difficult to really, debate on the subject that we have chosen, because I think each one of them is quite, aware of aware of the constitutional position. But yet I'll make some effort. Before I do so, I must say one thing, that amongst the qualities that Mr. Noorani had, he had a mercurial temper. I'm not sure whether Salman Khurshid decided to invite me today because of that quality or not. So, but there is a very interesting episode about late Mr. Noorani, that he was invited to deliver a lecture in Kashmir University. And he found that the Vice Chancellor was wearing shoes without socks, and he refused to, deliver the lecture. But having said that, he was an extraordinary lawyer, extraordinary Indian. He was a great constitutional expert. He defended the constitution and the constitutional morality very beautifully. He was very highly respected. He wrote many books, and amongst the issues that he took up very passionately was the Kashmir status. And I think it's really, it's really a great honor for me to be delivering the first A.G. Noorani Memorial Lecture. I feel privileged, I feel honored, and I'm grateful to you for inviting me. Constitution of India and Judiciary. The subject of today's discussion is as important as it was when the Constituent Assembly debated the draft constitution between 1946 to 1950. The constitutional framers were extraordinarily alive for the creation of an independent judiciary. Dr. Ambedkar, the spirit behind the constitution, made this abundantly clear while participating in the debate on 9th December 1948, when he said, and I quote, "British jurisprudence insists that there can be no right unless the constitution provides a remedy for it. It is the remedy that makes the right real. If there is no remedy, there is no right at all. And I am therefore not prepared to burden the constitution with a number of pious declarations which may sound as glittering generalities, but for which the constitution makes no provision by way of a remedy. It is much better to be limited in the scope of our rights and to make them real by enunciating remedies rather than to have a lot of pious wishes embodied in the constitution. I am very glad," he ended saying, "that this House has seen that the remedies that we have provided constitute a fundamental part of this constitution." Sri Krishnaswamy Iyer put it more beautifully on 8th November 1948. In regard to judiciary, the draft constitution also recognizes the importance of an independent judiciary for the proper working of democracy, especially of a federal constitution. Supreme Court, now just see this, I mean, is it true? The Supreme Court under the draft constitution has wider powers than any other court under any federal system in the world. To my mind, Constitution of India is remarkably people-centric. Very few people realize, people think that constitution is really to constitute the government, the legislature, the executive, and the judiciary. No, constitution has been created for the purpose of recognizing our existence as citizens, giving us the rights, and it is only to ensure that those rights are enjoyed by us that the constitutional framers create the executive, the legislature, and the judiciary. So each of these organs is obliged to ensure that the rights which are conferred upon us are made meaningful in every possible way. So I feel that constitution is people-centric. It is not really government-centric. It's not executive-centric. It's not power-centric. That's something which, those in power, including Mr. Salman Khurshid, should understand, that it is for us and us alone and not for them. The preamble itself connotes We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, goes on to secure to us, all citizens, justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, more important in today's times, equality of status and opportunity, and to promote fraternity among all, assuring the dignity of an individual with unity and integrity of nation. Fraternity is part of the preamble of the Constitution. It's one of the most fundamental, objectives of the Constitution, something which is completely forgotten today by both, unfortunately, those in power and I think by most citizens. Preamble thus lays down the fundamental principles or objectives underlying the Constitution, and it is therefore the basic structure of the Constitution. These principles are then given life in various parts of the Constitution in the form of rights, be it as constitutional or fundamental rights. Part 3, originally called Rights of Freedom by Sardar Vallabhbhai Patel Committee. He titled it Rights of Freedom. It was then subsequently changed by Dr. Ambedkar to be Fundamental Rights. Rights of Freedom by Sardar Vallabhbhai Patel Committee, which was the committee which really went into, contains fundamental rights including right to equality, Articles 14 to 18, right to freedom, Articles 19 to 22, right against exploitation, Articles 23 and 24, right to freedom of religion, Articles 25 and 26, and cultural and educational rights, Articles 29 and 30. But to ensure that these rights are sufficiently secured for citizens, the constitutional framers included in this very chapter right to constitutional remedies under Articles 32 to 35 and created Article 32, which guarantees right to move the Supreme Court for the enforcement of fundamental rights as a guarantee, and empowers the Supreme Court to issue directions, orders or writs as described therein for enforcement of any of the rights of Part 3. Subarticle 4 provides that the rights guaranteed by this article shall not be suspended except as otherwise provided by the Constitution. So these are, constitutional framers therefore were not only gave us the rights, but also added to them constitutional. Unfortunately, when there was no mobile, we all lived a very happy life. Today, it has taken away our peace of mind completely. I mean, you go to a cremation, people are talking on phone. You go to a prayer meeting, people are talking on phone. It's such an insult to you and a departed soul. We have lost our bearings. We've lost our bearings. Constitutional framers therefore not only gave fundamental rights to all citizens, but added to them a fundamental right for constitutional remedy to move the Supreme Court for its enforcements. This shows an extraordinary foresight and wisdom on the part of Ambedkar and his colleagues. No wonder, while debating this article on 9th of December 1948, Dr. Ambedkar himself said, "If I was asked to name any particular article in this constitution as the most important, an article without which the constitution would be a nullity, I could not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it, and I am glad that the House has realized its importance." He also said, for instance, if a man is arrested without filing a suit or a proceeding against the officer who arrests him, he can file a petition to the court for setting him at liberty. In a proceeding of this kind, where application is for a prerogative writ, all that the court can do is to ascertain whether the arrest is in accordance with law. The court at this stage will not entertain the question whether the law under which person is arrested is a good law or a bad law. All that the court can inquire in a habeas corpus proceeding is whether the arrest is lawful, and will not enter into the question, at least that's the practice of the court, of merits of the law. Now this is very important. Today, unfortunately, if people move Supreme Court, even in habeas corpus petitions, Supreme Court directs citizens to go to high courts. This is not what was intended by Ambedkar and his colleagues. And unfortunately, this very principle the very fundamental right, because putting Article 32 in Part 3 was an extraordinary piece of draftsmanship, because they knew that if these rights have to be honored, if these rights have to be protected, people must have a remedy. When the original draft of the Constitution came to Dr. Ambedkar, I remember, which was drafted by I forget the gentleman, the South Indian gentleman, whom RSS now says, no, B.N. Rao. RSS now claims that he was the spirit behind the arbitration, about the Constitution, which is incorrect. It was a draft, and thousands of cuts have been made in that draft. But Ambedkar said on the first day, when he was asked to speak by the chair, he said that this draft does give the rights, but doesn't give the remedy. And he says, therefore, it is really worthless to give rights to citizens unless there is a remedy. So 32 is an extraordinary piece of, wisdom on their part to give us that freedom, a fundamental right to move the Supreme Court. And we have to really knock sense into the minds of the Supreme Court that you have to help, you have to intervene, you have to protect us. And Supreme Court said so. In one of the earliest decisions of 7-judge bench of the Supreme Court has said that we have a duty to intervene. We cannot refuse to intervene if the court is moved for violation of fundamental rights, especially illegal arrests. But that's forgotten over last 7 decades. I don't know, for some reason or the other. The debate on 9th December provides not just lively discussion, but also apprehensions and anxiety that the framers had in their mind for future of India. Durgabai therefore said, G. Durgabai was a Madras member, "Sir, the right to move the Supreme Court by appropriate proceedings for enforcement of a person's right is a very valuable right that is guaranteed under this Constitution." Reverend Jerome D'Souza put it brilliantly. Again, a member, "Sir, it's because we all believe, and that is the implication of this chapter of fundamental rights, that the man has certain rights that are inalienable, that cannot be questioned by any humanly constituted legislative authority, that these fundamental rights are framed in a manner and a sanction and a protection given to them by this provision for appeal to Supreme Court." He added, "And the sacredness of the individual's personality, claims of his conscience are, as I venture to say, based upon a philosophy, an outlook of life which are essentially spiritual. It is because we believe that fullest and most integral definition of democracy includes and is based upon the sacredness of the individual, of his personality, and the claims of his conscience that we have framed these rights." And that's why I say that Constitution is people-centric. It is not power-centric. It has nothing to do about governance. It's about our existence. It is to give us individuals, the citizens, the development of the personality which is required in a philosophical sense, in an intellectual sense. Somebody asked Mr. D'Souza that what do you mean by these rights? I mean, you're all worthless. This is all part of the debate. He answers this very beautifully. He says, this is Reverend Jerome D'Souza, "If the convictions and faith of our people go away," remember this, look at this sagacity of the man. He's talking in 1947. "If the convictions and faith of our people go away, there is no use trying to protect these rights by sanctions. No amount of law can do anything. We must have conviction. We must have faith. The rights and the sanctions would be illusory. But if faith remains, no one will want to touch them." And that's what we must have. Faith in the Constitution. Constitution has nothing to do about religion. It's our life, our individual personality, our existence, which is protected in every which way. Intellectually, physically, emotionally, socially. Now that's what he says. To my mind, the faith that he refers to is the Constitution and constitutional morality. If we, I believe, if we are steadfast in maintaining that faith, the rights guaranteed under the Constitution will always remain sacrosanct. Sri Pokar Sahib Bahadur, one of the leading Muslim members of the assembly from Madras, he was amazing. Look at what he says. I must say that the recent behavior of certain provincial governments, now this is in 1947-48, I must say that recent behavior of certain provincial governments have taught us that it is very necessary to take careful measures to see that they are not allowed to behave in the manner they have behaved. I am referring to the way in which sacred rights and liberties of the persons are being dealt with by certain provincial governments under the cloak of powers that are said to possess. Very often, sir, it has become fashion with these provincial governments to say, well, some sort of emergency has arisen, and therefore, in public interest, we shall utilize the powers conferred by the Public Safety Act. Precisely what's happening today. And we shall have to curtail the liberties of so many people and put them in jail. He therefore expressed the hope. I would say that one principle which we have to bear in mind, and we should always keep in view in framing this constitution, is that ministries may come and ministries may go, but the judicial administration must go on unaffected by the vicissitudes in the lives of these ministries and changes in the government. It is more to preserve their own power, I mean, the power of the particular party or the clique in power, that these measures are resorted to rather than for public purpose. Such a state of affairs should never be allowed to be tolerated. Now look at the warning. These were all men and women who were extraordinary Indians, because they were born out of independent struggle. We are all born after, and most of us, after we got freedom. We have therefore no value for freedom. We have no respect for freedom struggle. And we certainly have no respect for those who laid lives for this country, who gave their joys, their happiness, their resources, their peace of mind. We just don't care. We have forgotten them completely. This is what is important for us to remember. He ended by saying that the powers of court should not be made to depend on the will and pleasure of the government. They should under no circumstances be allowed to interfere with the powers that vest in the courts of law. If the very guarantee of personal liberty on which a democratic form of government is based, and powers vested in courts of law to enforce such rights independently, are allowed to be interfered with, no one is safe. Of course, it is not a question of majority community. It is not a question of minority community. But the powers that be at the time clap in jails such of the individuals or groups of people whom they do not like, whom they do not want to be at liberty, perhaps for the fear that they may undermine the power that they are enjoying. Look at this. Each one of them was a prophet. Each one was a prophet who knew what India is going to be in 2025, in 50 or 70 years. We have completely lost our understanding of freedom, our respect for freedom, and our protection for freedoms. Everybody is responsible. It's not just the institutions, the executive, the legislature, or the judiciary. But we as citizens have also perhaps forgotten what freedom means. And that's why we are not willing to stand up and clamor for that freedom, which was envisaged by constitutional framers when they worked hard to give this document to us. We just don't care. Interestingly, referring to the right to freedom of religion in Article 25 and 26, Professor Shibanlal Saxena on the very day said, now this is, just see, I personally feel that the majority has gone to the farthest extent in this matter. Look at this. These are very important words, and especially for the community to understand. This is Professor Saxena. I personally feel that majority has gone to the farthest in the extent in this matter. And minority committee was chaired by Sardar Vallabhbhai Patel. It's very important for us to remember. I may also point out one thing. The Fundamental Rights Committee was appointed before the partition took place. In fact, these rights were written in this form before the partition had taken place. Yet we have not changed them. I am not letting out a secret. Now just see this. This is important to remember and remind those in power today. I am not letting out a secret when I say that our great leader Sardar Patel told us, kindly do not interfere with these rights, religious and cultural, because they form part of an agreement arrived at before the partition. Now have we ever stressed on this? Have we ever reminded those in power that this is what your Sardar, whose statue you have created at a cost of 3,500 crores of rupees, told this country? This is what is important. Yet we have not changed these rights because our leader has told us not to interfere with them. I think the real guarantee of the minority is the goodwill of the majority. And he therefore hoped that we would be able to create a nation based on the ideals of Mahatma Gandhi to have in our country a real secular state. Professor N.G. Ranga, another very, outspoken member of the Constituent Assembly, expressed the fear that there is a worldwide conflict today. This is talking about in 47, 48. There is worldwide conflict today between two great ideologies. There is totalitarianism on one side, and on the other hand, there is democracy. In this conflict, we have to decide what we are going to do. These fundamental rights can come to be exercised only by that society and those individuals who have a due respect for the law, who have due respect for the fundamental rights of other people among with themselves, and who therefore are prepared to behave themselves with a due sense of responsibility and restraint. Whenever such conditions are not obtained, he said, and whenever these groups and parties who organize and make it their business to destroy the state and to try and capture the state, certainly it would not be possible for any state or society to respect these fundamental rights. That is the first prerequisite for the exercise of these fundamental rights. He therefore expressed apprehension. Another thing is not the Supreme Court which is going to ensure the exercise of these fundamental rights to individuals or groups, as much as individuals and groups' own capacity to stand up on its own fundamental rights and make necessary sacrifice. Don't look at the judiciary. Stand up and remind the nation that these are basic, inalienable human values. Let us not steer away from them. This is what he therefore advocated satyagraha in a non-violent Gandhian fashion and called it a safeguard for citizens' fundamental rights. He therefore lamented that a state which is not prepared to restrain its own unorganized or disorganized majorities who believe in inflicting private punishment upon various people, whether they are organized or not, such a state does not deserve to exist. It is also quite possible that when an organized majority is functioning through the state and begins to misbehave in this fashion, Supreme Court might be set at naught, as it happened in Nazi Germany and fascist Italy. While he did say that satyagraha need not be enshrined in the Constitution as a fundamental right, it can only be enshrined in our hearts, in the capacity of people to sacrifice. He said, if ever any group or individual were to try to establish totalitarianism in this country, especially to establish a totalitarian state, then it will be the sacred duty of the Supreme Court, as well as that of President of Republic of this country, to see that this constitution is maintained at all costs and these fundamental rights are not allowed to be exercised by those people or groups in such a way as to jeopardize our society. Now look at this. Each one of them was men and women of extraordinary caliber. Every day I read Constituent Assembly debates. They run into thousands of pages. And each page gives me a different, idea about them. Each page. On every subject they have deliberated is mind-blowing. Ambedkar allayed these fears by saying, Ambedkar stands up after hearing them, that even proclamation of emergency, only rights under Article 13, which is now Article 19, can be suspended, and that all other articles and rights guaranteed in Part 3 will remain intact, and that none of them would be affected. Which means liberty and life cannot be taken away. Which means that right to move Supreme Court cannot be trifled with, even in an emergency. That's what Ambedkar said. Constitutional framers therefore gave us Article 226 in addition, and empowered the high courts to issue writs, orders or directions for enforcement of not only fundamental rights, but some. So they said that if any such order is made, if any such clause, this Article 13, to say that this is void. This is not a defensive mechanism. This is, to my mind, an offensive mechanism. It's a shield against every unconstitutional order which tries to take away our rights. So they were so. It also declares that the existing laws which were inconsistent with fundamental rights chapter were void. This is an amazing provision and a deeming fiction created by constitutional makers. It's a shield to preserve fundamental rights against every governmental action. The court has necessarily an obligation, therefore, the Supreme Court, to accept this position, and no actual declaration from the court is required that any action is void. The Constitution thus strives to make our judiciary independent of the executive and empowers it with sufficient powers to protect fundamental and constitutional rights. Throughout the Constituent Assembly debates, member after member expressed apprehension about independence of the judiciary. The manner of appointment of judges, their retiring ages, their qualifications, their post-retiring jobs, all came up for discussions. Pandit Jawaharlal Nehru himself stated on 24th May 1949, it is important that these judges should not only be first rate, but should be acknowledged to be first rate in the country. Whom do we appoint today? I mean, collegiums appoint anybody, they just sit across as a friends, and Salman Bhai, this is my friend, Salman Bhai will say, Dushyant, this is my friend, and they appoint judges. No. Pandit Nehru said, that's not the way. That's not the way. It is important that these judges should be not only first rate, but should be acknowledged to be first rate in the country, and of the highest integrity if necessary. People who can stand up against the executive government and whoever may come in their way. These are the kind of judges that constitutional framers had in mind. This is the judiciary they wanted. Ambedkar himself said on that day, with regard to this matter, I quite agree that the point raised is of greatest importance. There can be no difference of opinion in the House that our judiciary must both be independent of the executive and must also be competent in itself. The draft article therefore steers middle course. It does not make President the supreme and absolute authority in matter of making appointments. It does not also import influence of legislature. The provision of the article is consultation. So he went for the middle path to ensure that the appointments of Supreme Court and High Courts were made as unfortunately by this so-called judgment in the second judge's case. And this is precisely what Ambedkar had used the word. I will see this. I think to allow the Chief Justice practically a veto upon the appointment of judges is really to transfer the authority to the Chief Justice, which we are not prepared to vest in the President or the government of the day. I therefore think that this is a dangerous proposition. And this is precisely what the Supreme Court did when they constituted so-called collegium headed by Chief Justice to make the appointments. They really have adopted the dangerous proposition that Ambedkar wanted to expressly avoid. And we didn't say a word about it. Everybody said, oh, independence of judiciary, this. Ambedkar, unfortunately, was a great man, great prophet, great jurist, and one of the greatest Indians to be ever born. But I think he was he believed too much in us. He really didn't think that we will be where we are today, 70 years down the road. And therefore, he did not prohibit the acceptance of office by members of judiciary post-retirement as desired by many members. In rejecting their demand, he said, judiciary decides. Now look at look at how much he trusted us. He said, why should I prohibit judges from accepting post-retirement positions in government? He says, the judiciary decides cases in which government has, if at all, remotest interest. In fact, no interest at all. The judiciary is engaged in deciding the issue between citizens and very rarely between citizens and government. Consequently, the chances of influencing the conduct of a member of judiciary by government are very remote, and therefore the provision which we applied to the Federal Public Services Commission have no place so far as the judiciary is concerned. Now little did he realize that 50, 40, 50, 60, 70 years later, the biggest litigant in the country would be the governments, and that the citizens will be daily in conflict with the government to for enforcement of their constitutional and fundamental rights. But this is how he believed. He again said that I have said relation between executive and judiciary are so separate and distinct that executive has hardly any chance of influencing the judgment of the judiciary. Now, little did he realize that what kind of executive will be and what kind of judges will be, 50 or 70 years later. But this is how, they never believed that country will fall to such, lows as we have fallen today. Today, the biggest litigant is government, as I said. Professor K.T. Shah, while discussing this is again a very separation of judiciary from the executive was a subject that they wanted to debate. Ambedkar put it in directive principles of the state policy, didn't put it as a fundamental objective, Article 40A, 40. And now Article 40A, Professor K.T. Shah wanted to add. He wanted to say that there shall be complete separation of powers as between principal organs of state, legislature, executive and judiciary. Professor K.T. Shah said, why do I need it? For one thing, sir, if you maintain complete independence of all three, you will secure a measure of independence between judiciary, for example, and the executive, or between judiciary and legislature. This, in my view, is of the highest importance in maintaining liberty of the subject, the civil liberties and rule of law. If there was a contact between judiciary and legislature, for instance, if it was possible to interchange between highest judicial officers and membership of the legislature, then I am afraid the interpretation of law will be guided much more by party influence than by intrinsic merits of each case. So Rajya Sabha seats to retired judges, precisely what they were worried about. Professor K.T. Shah, a very leading person, he was an advisor to the Kashmir government in those days. He further said, if contact or connection is maintained between judiciary and executive organs of the state, there is also possibility of undue influence, of misleading, of misdirecting, misinfluencing those who are appointed to interpret the constitution, those who are appointed to be guardians of civil liberties, those who have to administer justice. He was aware that in the environment in which we live today, he said, in the tradition in which our judicial system has been evolved, I am afraid justice is a very costly luxury, thanks to us. And what has evolved with time is most costly and most wasteful, most extravagant system of legal advice and legal assistance by professional lawyers, which only those who have undergone protected litigation know how costly it is, how confusing and how prohibitive it is to ordinary mortals. So even in those days, they were worried about the role of the lawyers. And I must say that, I feel, honestly, I don't know how my very dear friends here from the bar feel, but I must confess that we as lawyers have failed miserably, both on an individual basis and collectively as bar associations, or even the statutory bar bodies like the Bar Council of India. Now this is exactly, He feared, but for the possibility of transition from high judicial office to an equally high or sonorous executive office, so long would your judiciary be open to suspicion, so long your administration of justice was suffered by personal privileges, personal ambitions, so long therefore you will not be able to maintain your civil liberties to the degree and manner of purity that is highly desirable. Sibalal Saxena once again remarked, in this regard I have heard the most eminent authorities in the assembly to say, today high courts are not independent. He is saying then. Just imagine, today high courts are not independent. They are influenced by political consequences of their actions. I hope in future our Supreme Court will be free from these influences and that they will do what is necessary and observe the principles inherent in this constitution. This is what they feared. Ambedkar merely retorted by saying on 10 December 1948, there is no dispute whatever that executive should be separated from judiciary, but did not accept the amendments which were proposed by Shah and Saxena. True, Article 39A today, which is Article 50 in the Constitution, has been incorporated as a directive principle. But Dr. Ambedkar said that we deliberately did not make it a matter of fundamental principle, because if we had made it a matter of fundamental principle, it would have become absolutely obligatory, instantaneously on passing of Constitution, to bring about separation of judiciary and executive. In fact, original draft had provided 3 years period, which also Dr. Ambedkar removed. He said that it's not necessary to do it in 3 years. So this remains now a directive principles as to how judiciary should be, separate from the executive. Loknath Mishra, one of the other members from Orissa, went to say, therefore the mere separation of judiciary from executive will not serve our purpose. We require something more. He suggested, looking at the state of affairs and the legal profession as it was, therefore I say, unless the professions of law and medicine become a state business, you cannot have proper administration of justice, either for rights or for health and diseases. So this is what, so why did Constituent Assembly debate so much on independence of judiciary? And why did it empower High Courts, Supreme Court, those powers and duties to enforce them? Why did it make the subordinate judiciary under the control of the High Court? That is because throughout the debates on fundamental rights, members after members expressed apprehensions about the affairs of the state prevailing then and that will prevail in future. Professor K.T. Shah again on 1st December 48 said, the liberty of person, look at this, how these people must have been, I don't know what they were made of. The liberty of the person, ever since the consciousness of civil liberties has come upon the people, has been the main battleground of autocrats and those fighting against them. In no single instance, other than this, has the power of autocracy wanted to assert itself against the just claims of the individuals to be respected in regard to his personal freedom. The liberty of the person to fight against any arbitrary arrest, detention, without due process has been the basis of English constitutional growth and also French constitution that was born after revolution. The autocrat, now he says, the autocrat, the despot, has always wished, whenever he was bankrupt of any other argument. So it doesn't matter, unemployment, poverty, gap between rich and poor, but all that is not important. So when you become bankrupt of any other argument, just to shut up those who do not agree with him. It was therefore that any time the slightest difference of opinion was expressed, the slightest inconvenience or embarrassment was likely to be caused by an individual, the only course open to those who wanted to exercise autocratic power was to imprison or arrest or detain such a person without charge or trial. This is the fears that these people have expressed for us. We have never cared to see that. We have never cared to see. We never, we have a democracy. It's, I think, it's only in form. Ambedkar had said very categorically, if there is a landslide, we will retain democracy in form, but we will lose it in fact. Exactly what happened when Mrs. Gandhi was in power during emergency, exactly what's happening now. We are having a democracy in form, not in fact. And they were afraid. Mehboob Ali Beg Sahib Bahadur, another member, said, it's only in German constitution that we find restrictions, such as those contained in Article 19, sub-articles 2 to 6. These members wanted these rights to be unconditional. They didn't want this power that state can bring a law and impose reasonable restrictions to enjoy constitutional rights under Article 19. So this Mehboob Ali Beg Sahib Bahadur says that these are found only in German constitution. It is only in German constitution that fundamental rights were subject to provisions of law that may be made by legislature. That means that the citizens could enjoy only those rights which legislature would give them, would permit them to enjoy from time to time. That cuts at the very root of fundamental rights, and fundamental rights cease to be fundamental. So you have today all kinds of laws, all kinds of orders which are passed in the garb of powers under sub-articles 2 to 6. Be it on freedom of speech, be it on right to do business, be it on right to residency, be it in right to move from one place to another. On every one of those rights, curtailments are imposed. But he said that then these rights are useless. I dare say, sir, you know the result. He says, Mehboob Ali Beg Sahib. I dare say, sir, you know what was the result because of the German constitution. Hitler could make his legislature pass any law, put Germans in concentration camps without trial under the provisions of law made by the legislature of Germany. Totalitarianism, fascism was the result. This is what they feared. Farm laws. One fine morning, Parliament passes farm laws, then without any debate. Then after some time, when 6 protests in a satyagraha, the government realizes that now we can't, they withdraw them without a debate. Now, is this the kind of a parliament which was envisaged? And this is precisely the fear that this great man, Mehboob Ali Beg Sahib Bahadur, expressed. Kanhayalal Munshi, one of the greatest intellectuals, amazing guy, academician, Bharatiya Vidya Bhavan's founder, great writer in Gujarati literature. Some of his novels are of world class. Jai Somnath, Patanni Prabhuta, these are the novels that brilliant. Great lawyer, freedom fighter. Kanhayalal Munshi says, but the public opinion has changed considerably since then, and now that we have a democratic government, a line must be drawn between criticism of government, which should be welcome, and incitement, which would undermine the security or order on which civilized life is based, or which is calculated to overthrow the government. Now see his next sentence. As a matter of fact, the essence of democracy is criticism of government. Essence of democracy is criticism of government. This is that great, Indian telling. Sardar Hukam Singh again objected and said that if other countries like US have placed full confidence in judiciary and their long experience they have found that confidence was not misplaced, why should we not depend on similar guardians to protect individual liberties and the state interest instead of hedging around the freedoms by so many exceptions and exemptions under the subclauses? He said, let judiciary control it. Why should we put it in constitution that government has power to bring law and put reasonable, restrictions? Ambedkar, however, defended the provision. Now, his defense is important, which unfortunately has been singularly missed in our jurisprudence. Ambedkar defended the provisions, saying, now fundamental article is Article 8, which is now Article 13. I said it's void. Is Article 8, which specifically without any kind of reservation says that any existing law which is inconsistent with fundamental rights as enacted in this part of Constitution is void. That is a fundamental proposition. Therefore, drafting committee felt that they have laid down in Article 8 the full and complete proposition that any existing law, insofar as it is inconsistent with fundamental rights, will stand abrogated. He therefore felt that only reasonable restrictions were permissible and existing law was saved only to a limited extent and only if it is not in conflict with fundamental rights. Now our courts have justified every kind of legislations, every kind of executive orders, without really understanding that even if it is remotely violative of our fundamental rights, then it is void. You don't need, you have to understand, Constitution declares it to be void. I don't need a certificate from Supreme Court. Constitution says it is void. Constitution of India is to empower the people and to make individual personalities to grow without any hindrance in a civilized manner and in a civilized state. State is secondary. State is secondary under the Constitution and subservient to us, the citizens. It is not primary. We are the primary characters. The state has been prohibited from interfering with individuals' rights so as to allow individuals to grow in a philosophical or spiritual manner in mind and body. Individual has freedoms which are sacrosanct and necessary for that growth. The entire scheme of the Constitution providing for creation of governments at the federal and state levels, its functionaries, legislature, the parliament, state legislatures, judiciary, election commission, CAG, etc., are all created and do exist with those limitations. They are there to serve us. They are not there to enjoy their powers or exert their powers. They must exercise the powers in such a way on a daily basis that our rights are enjoyed by us to the fullest. That's the purpose of the Constitution. Judiciary is therefore the arbiter and interpreter of Constitution and its guarantees. Time and again, Supreme Court has declared itself to be the ultimate protector of fundamental rights, calling itself sentinel on the qui vive, the ultimate guardian of rule of law. I don't know why these fancy words are used by Supreme Court, because I feel, being a lawyer for 46 years, that Supreme Court has hardly protected fundamental rights of citizens. It's not just ADM Jabalpur. Every day you see in our courts ADM Jabalpurs. So it even went to the extent of saying in 50s that writ under Article 32 must be entertained because Supreme Court just does not have power, but also duty to entertain. Yet over last 7 decades, judiciary has indeed been unable to protect fundamental rights of citizens in letter and spirit. There is therefore serious erosion of constitutional values and principles enshrined in the preamble, and dilution and many a times negation of fundamental rights. Constitutional framers wanted it to be strong, independent, even while expressing fears that it may lose its independence. But the Constitution has not failed. Constitution is sacrosanct. Sadly, the people who were called upon to administer it have failed. This was the apprehension expressed by Chairman of Constituent Assembly, Dr. Rajendra Prasad, who became our first president, as also Dr. B.R. Ambedkar. Both said that Constitution will fail not because the document is faulty. It will fail because man has become vile. That's why it will fail. As feared by Dr. Ambedkar, however, we too have failed, as we have not mustered sufficient strength to stand up and follow the ideals of Mahatma Gandhi and carry forward Satyagraha, as recognized by Professor N.G. Ranga, in a non-violent manner. Ranga wanted to uphold, these rights, not as constitutional rights, but as our personal obligation to the state, to the fellow citizens, to our fellow, individuals. Let us hope and trust that future has in store a better India with a strong democracy and complete and truthful enforcement of fundamental and constitutional rights, so that every citizen is able to develop his personality fully, spiritually, physically, mentally, and morally. Thank you very, very much. Thank you so much. I am grateful for this invitation. I feel honored and privileged, and it's been a great joy to be amongst you. And I do hope and trust that you will be able to carry this message forward. There is a very strong duty cast on the lawyers, young lawyers, and I do hope, I've been constantly arguing with my friends at the bar, that young lawyers must stand up, because unless they stand up, we will not be able to really enjoy what constitutional framers. So we must remember their sacrifices and continue our satyagrahas. Thank you very, very much. I'll stand here. No problem.
Thank you, sir, for that very, very passionate talk. I mean, that's what we are used to seeing you. We have a whole generation of lawyers has learned from your passionate and fearless advocacy. My question is that today we are struggling with a new issue. One, of course, is the issue of appointments, but also removal now, because we have seen a situation where one judge clearly unfit, doesn't have an understanding of his constitutional role, speaking contrary to what the oath he has taken. And we have seen the collegians sort of struggle with what is the solution. And Justice Royal Society, I think today in the Express said that there are soft options. We really don't have a credible option. So, and the political system of impeachment is foreclosed because of the political situation at the time. So I just wanted to get your views on, when you have such an obvious case of judicial misconduct, what else can be done, and how do you foresee what can be effectively done in these kind of cases?
See, I mean, I would agree that the Constitution, unfortunately, provides a mechanism which is extremely cumbersome and virtually impossible to really achieve the result. Therefore, the only thing that a good Chief Justice would do, as was done by Chief Justice Venkat Chalaya, would take away the judicial work from the concerned judge. And that is something which Chief Justice and the Collegium have to, advise the Chief Justice of the concerned High Court to do. There is no other way we can deal with this situation, unfortunately. But of course, continued criticism of the conduct of the judge is also something which should take place, and that perhaps would bring some kind of moral pressure on the judge in a right way, in a respectful way, in a constitutional way, to impress upon the judge why is it that why did Sardar Patel wanted the minority community to have these rights, and why constitutional framers never wanted this country to be a Hindu Rashtra. They wanted it to be a secular nation. And secularism is not only because Mrs. Gandhi added the word secular in the preamble. If you go through the thread of the Constitution, article after article refers to the secular philosophy. And the debates really provide a clear-cut idea that each one of the members wanted, nobody really wanted it otherwise. So I have not even seen people like Shyama Prasad Mukherjee or Pandit Madan Mohan Malviya during the Constituent Assembly debate arguing to the contrary. So, I mean, it was virtually, and minority report was by Sardar Patel. He says it was unanimously done. So that has to be impressed upon the people and the judge concerned that what you are saying is completely, contrary to the constitutional ethos and morality.
A common man is waiting for the justice, and there are dates after dates, waiting for 10 years, 15 years. And what is the responsibility of the judiciary? Why there is no time limit? And how long a common man can go on waiting? 10 years, 15 years, 20 years, and still no justice.
Yes, I agree.
What is the way out?
There is no way out as the matters stand today. See, the per capita population of judges is one of the lowest in India in the world. We need to increase the strength of the judges, one. We need to increase the infrastructure of the judicial system, that's the second. Now these two things the executive would not want, because the executive is not interested in giving judiciary more space, because that curtails their own space. But having said that, I think what is really, I mean, I don't mean any disrespect to us, but I think our own character has come down very badly. And therefore it is well nigh impossible. I'm sure when you went to school, you found teachers who were extraordinary. Today to find those extraordinary teachers is virtually impossible. Whatever we are, whatever I am, and I have no doubt all of you have that experience, I am here because of what my father and my mother taught me. My mother was an uneducated woman, and we are Brahmin. She was a very, very devout Shivite. She observed Chaturmas and Shravan Mas without eating anything. And she would go to temple after giving us food, barefoot, in hot summer. We were brought up in that kind of an extremely orthodox environment. Yet my father and mother, both, had unimpeachable love for every human being. Every human being. My father's best friend was a Muslim gentleman, Palejwala, who became Speaker of the Gujarat Assembly in the 60s. And I mean, whenever he would come by, he would joke with my mother on many issues. And so the kind of upbringing that we got, that upbringing is missing today. And social media, of course, is adding to that. So the character, now judges are therefore not, we are not getting the best of the judges. The bar is equally irresponsible. The bar doesn't want to argue the cases quickly. And bar doesn't force the judges to dispose of cases. Bar is happy, lawyers are happy with the adjournments. That's my belief. So and of course, all kinds of nonsensical cases are now coming up. I mean, like take for check bouncing. There was a time when, gentleman's word would be respected. Today, despite the law, which says that you will be sent to jail if your check is dishonored, people dishonor checks. What do? That's our character, which has fallen. So, there are several issues which are there, and I don't think anybody has an answer, honestly. I'm a pessimist. I'm a permanent pessimist. There is no solution to judicial, ills. And I don't think anybody has expressed any desire in my last 46 years, any Chief Justice or anybody else or any Prime Minister, to really make improvement in it. Nobody bothers about it.
Sir, thank you very much for such enlightening speech. Sir, we have seen in last few years, we have closely observed, you have much more experience and knowledge about how the institutions have functioned. You spoke about faith in constitution, faith in institution, referring to Mr. D'Souza's statement. Now, it's not that only courts or institutions are not working. We also find it works where they want to, and it doesn't work where they don't want. And those areas where they don't work is basically of that area where those marginalized minorities, tribals, these are the people who are sufferers. Now, under this situation, it becomes very chaotic situation that at the same time institutions and legislature, everybody is working, and parallelly they are not working. This is a very, very frustrating moment. What would be your message to those affected communities to have a step forward?
See, as I said, Ambedkar, put it very brilliantly once. Ambedkar puts it, I will tell you in his exact words, that it is very easy to pervert the constitution. You merely need to change the form of the government. And that's precisely what is happening. And it's not just confined to this, it happened with Mrs. Gandhi. I am very clear in my mind, without any disrespect, that the downfall of this country started with Mrs. Gandhi after 1975. And that has continued without any abatement. No effort has been made by any government to really stop this nonsense. So we really, it's not, I feel that politics in this country has hijacked the nation from us. We are completely helpless as citizens. We have no role to play. We have no voice. They do whatever they want to do, irrespective of political platform, irrespective of political party. Power has corrupted them completely. And absolute power corrupts absolutely, as was said more than 2,000 years ago. So it's something which is very difficult to understand what can be done. There is no answer. And that's why Professor Ranga talks about that satyagraha. I am against revolution. I don't think that, revolutionary means armed struggles can really are the answers. No, they are not. We must have, therefore, a peaceful, transition to those ideals which were, behind the constitutional frameworks. It's very, I do feel I do feel very strongly that not just the Muslims, but even the Dalits and even women in this country are not well treated. I mean, we all know what's happening to women in this country. Domestic violence is so common. Rapes, how many rapes are reported today? 10%. Look at the treatment of Dalits that we have. That in Gujarat, the Dalit wanted to go on for his wedding on a horse and he was killed along with his horse. Last week only you saw that in Rajasthan, a Dalit went for his wedding on a horse with a police party. Hundreds of policemen were guarding. Now what kind of a country we have? So it is, unless we, the society is too primitive. We are a feudal society essentially. And it will take long time for us to change our mindset. That every human being must be respected. We don't do that. I don't know. We need a Gandhi. We need maybe Aurobindo. We need Vivekanand. I don't know. We need some great human being to be born. Unless that happens, it's not easy. We need Buddha. We need Prophet Muhammad. We need Mahavir. We need all these people together to really transform us. Otherwise we won't be able to transform ourselves.
Hello, this is Nilesh. So first of all, I congratulate Iqbal Saab and Salman Khurshid Saab and you also for our election. My question is about yesterday I was sitting with an MP who happened to be a JPC member of Waqf Board B, and he was saying that this bill will not stand in the Supreme Court as Article 25 doesn't permit such kind of amendment. I want to know your opinion on it.
See, I have not seen the bill, so I really won't be able to give you an opinion. But I am very clear, and that's why I read that statement of Sardar Patel, quoted by someone, that these rights are really very crucial. They were not given, in haste and without any deeper thought by the constitutional framers. They wanted the identity of the minorities to be protected. And therefore their culture to be protected, their faith to be protected, their right to religion to be protected, their practices to be protected, their cultural and religious places to be protected. But we are seeing that there are consistent attacks on them, which is bound to happen. It's happened throughout centuries. It's not just happening now. I'm sure it happened during the Islamic period in India, and it's now happening in the most modern parts of the world. Look at Hungary. Orban is completely far right. America, what we are experiencing in last few days is something shocking. I mean, for a president to say that the accident that took place, that aircraft, is because colored people are admitted into the administration. I mean, what more shocking things than... So, these are the challenges. I would say, my feeling is that, and this is where, unfortunately, the opposition is not able to, rise. You should never criticize what is happening frontally. Instead, you should put up what was really envisaged to be a great country like India. So you quote again and again what constitutional framers thought about it. It's no point, if you abuse the Prime Minister, I think he gets 2,000 more votes with heavy abuse. It's nonsensical. After all, he's the Prime Minister. I may disagree with him, but I must respect my Prime Minister. I can't, abuse him as, or the President, that, you can't say things like that, that she is, what did Sonia ji said? Something very, yeah, you don't make even those remarks in, jest. Everybody must be respected. I should respect you and you should respect me in return. We have no right to, be personal with each other. But we have a right to say that, your question is not a proper question. It's a different thing. Or that my answer is not a proper answer for you to say. So that respect in the society, unfortunately, has, and this is where, you go to Lucknow and you meet the old Muslims, the kind of respect that they had, even in their, in their behavior, in their language, was so beautiful. I don't understand Urdu so much, but the way they talk, I was in Lucknow and I went to some Muslim friends. It was so touching, heart-rendering. That tehzeeb, what do you call tehzeeb? That's missing in society. We have to bring that back. We have to bring that back.
Good evening, sir. Thank you so much for such a
I'm in my very first year of law, studying at the Faculty of Law, Delhi University. And what I have noticed, like till my very second semester, um, our family law teachers who are deeply sexist and Islamophobic, torts teachers who are doing a PhD in Manusmriti and saying how Indian jurisprudence and jurisprudence itself should be derived from Manusmriti and not from other jurisprudence around like the world. And I see many of my friends and classmates not being happy with this behavior, yet at the same time not opposing this either, because they think that the moment that they will oppose it, their careers, their like academic life, everything will go down the drain. So how to combat that here?
I'll give you a very easy answer. For 7 years of my college, I never went into classroom. So my mind was never, nobody could abuse my mind. But no, you have to attend the classroom and you must sit there and listen to them, hear from here and take it out from here. That's okay. And one of the biggest challenges that India is facing today is saffronization of education system. We are seeing that. But it is not difficult to counter. You have to, as I said, you have to have your faith, as Reverend D'Souza said. If you keep that faith, there is nothing which can come in the way of your learning. I mean, that's all right. That's also part of it. Maybe, you will also get some idea of Manusmriti. Fair enough. But you don't believe in that Manusmriti. You just hear it and you know as a matter of knowledge, but not as a matter of imbibing into your value system. So don't worry about it. Ignore it.
My suggestion is that this lecture should be published in a proceeding under the aegis of Islamic Cultural Center, under your guidance, because it is a very good lecture, and we should start such type of lectures so that the message should go among the masses. The only solution is that we have to create awareness. This is one point for the publication of your lecture here in a proceeding, and second one, that some cell may be created here in Islamic Center to spread the knowledge about Constitution of India, because our students, our villagers, our other friends, they don't know much and they are not aware about Constitution. So what contribution can be done through this Islamic Center to spread the knowledge about Constitution, to save the Constitution or to preserve the Constitution of India? So there should be a cell here under the guidance. Yes. So these are some of the points, because you have touched various points here regarding the preservation of Constitution, freedom fighters, and we should have a biography of the freedom fighters here under this Islamic Center. So many freedom fighters, they have laid down their lives. So we can do a lot of work in this area.
See, best is, I'll give you one thing. this argument about a conversion, for example, even at the height of Mughal Empire, the population of Muslims did not increase 20% in India. And as far as I know, in the 1930, the first census was done by the British. In that also, the population was, at that time, it went up to 24%. So it is during the British period that it increased from 20 to 24%. So, but there is a disinformation going on that the population. So, there are many things which can be countered, but the community has to have people who are, who can communicate. If people don't communicate and people, just remain silent, then of course, whoever has a louder voice will be heard. It's very simple as that. Unless you stand up and speak about it, and nobody, these are facts. These are facts. And I have no doubt that Iqbal Sahab and all will perhaps. The biggest problem of India is that Constitution is not taught in schools. If it was taught in schools in the right way, every child will be a responsible child. Today we are completely irresponsible. See the way we drive on the roads. You may be waiting at a red light for 10 minutes. waiting for the light to come. Suddenly some Johnny will come from back, put his car in front of you or a scooter in front of you, and he will want to just go. I mean, your neighbor will throw his, dirt towards your side. It's very common. I mean, we are, I'm sorry to say, we are a lawless nation. There is no rule of law. If anybody thinks that India has rule of law, then he is sadly mistaken. There is no rule of law. It's only the...
I'm Paul Siddiqui, an old member of ISCC and retired engineering service officer. In my about 40 years of career in government, I've seen many High Court and Supreme Court judgments from human perspective. I want to know your views on Nyayapal, on the pattern of Lokpal, to have further remedy beyond Supreme Court. By we the people. Peaceful satyagraha, like Anna Hazare did, and see the rest is history.
No, people will, I think it's only the time that will be the best solution. It's only time that will perhaps improve the situation. Even if you put some court above the Supreme Court, I can tell you it will make as many mistakes as Supreme Court does. So it's not going to be a better court. It's a...
मैं माजरत चाहता हूँ तो उर्दू चूँकि पाबंदी नहीं लगी है तो मैं बोल सकता हूँ।
नहीं कोई पाबंदी नहीं, जवाब कभी कोई बैरियर होती भी नहीं।
दूसरा मैं माजरत इसलिए चाहता था कि मैं दुष्यंत दवे साहब से सवाल करने की जरूरत मैं कर नहीं सकता कि मैं कानूनदान नहीं हूँ, और इस मौजू से मुताल्लिक मैं बात नहीं करने जा रहा हूँ, लेकिन नूरानी साहब के ताल्लुक से बात की है। एक मैसेज मेरे पास था, इसलिए मैंने ये जहमत आपको दी है कि हम ये बहुत अच्छा है कि नूरानी साहब पे हम लेक्चर्स कर रहे हैं और इतने एलिगेंट लेक्चर्स तो हमारी मालूमात में इजाफा मुस्तकिल करते हैं। हालांकि हम आज भी क्रिटिक है कंप्यूटर ऑफ इंडिया के, लेकिन बहुत अहम चीज़ें आपने बताई हैं। लेकिन नूरानी साहब के इस लेक्चर सीरीज के साथ एक बहुत बड़ा असासा नूरानी साहब ने अपनी ज़ाती लाइब्रेरी के तौर पर छोड़ा है, और अगर उसको बचाने की कोशिश हमने नहीं की तो हमें बर्बाद करने वालों को कसूरवार ठहराने का कोई हक नहीं। इसलिए मेरी सेक्टर के सदर साहब तशरीफ फरमा है, आप तशरीफ फरमाए। मेरी ये दरख्वास्त है कि लीगली और लॉफुल तरीके से बहुत बड़ा कीमती माजी और तारीख का सरमाया छोड़ा है उन्होंने, तो मुफ्त में अवेलेबल है। अगर सेंटर किसी सूरत, मुझे इफ्तिखार गिलानी साहब ने ऑनलाइन भी कहा था इससे पहले बहुत सीनियर जर्नलिस्ट ने, अभी इस्तांबुल में भी उन्होंने मुझे इस पर लंबी गुफ्तगू की। अगर सेंटर वो लाइब्रेरी ले आए तो शायद किसी हद तक हम अपनी तारीख को और अपनी माजी को बचाने में कामयाब हो सके। मेरी दस्तबस्ता इल्तमास है अरबाबे सेंटर से। बहुत शुक्रिया, और मैं बहुत शुक्रगुजार हूँ मोहतरम दुष्यंत दवे साहब का कि आपने हमको एनलाइटन किया। बहुत शुक्रिया।
Sir, I cannot dare to ask a question to you.
No, it's not. Why do you say that? We are all friends.
No, it's just very nice of you saying, sir. He's also a lawyer. The point is,
Of course I know him.
point is,
I
sir,
don't miss anybody in my bar.
you-
I have not been elected 3 times president without knowing my... You think you only voted for me or what?
So, sir, you said that 7 years you never attended the college. That's very nice. Never wanted to ask also, but it has compelled me to ask, sir. The young student wanted to know what to do. And then you are so learned, and the experience and knowledge you shared with us. Without going to college, what is the source, sir?
See, I'll tell you. It's a very good question. I'll tell you. Those 7 years I invested in reading everything that I could. There is nothing that I have not read in those 7 years. I mean, every literature from every part of the world I read, whether it was Hungarian, whether it was French, whether it was American, whether it was British, whether it was Czechoslovakian, whether it was Gujarati literature, which I used to enjoy reading. I read and read and read. I mean, I must have really read maybe 10, 12,000 books during those 7 years. And I still continue to read. There is not a week. I feel that you don't get educated only by attending classes. Even today I would go to Bari and Sons every week and would pick up 2 books. Every week, one a fiction and one a non-fiction. And I will read them throughout the week. throughout the week. I'm right now reading Arun Shori's book on Savarkar. It's a brilliant book, absolutely outstanding. So, it's just the joy of reading. I read 4 newspapers a day. I read every magazine that I can lay my hands on. So, it's just the reading. And I read Constituent Assembly debates. I read history a lot. Bharatiya Vidya Bhavan has a publication of, India's history, slightly slanted. But it's perhaps one of the best compilation in about 10 volumes, right from the Vedic period to independence struggle. And when you read them, especially independence struggle, you realize that how wrong people are criticizing Gandhi for partition. Some of the articles that Gandhiji wrote in Harijan, some of the letters that he sent to Mountbatten, you should see, how Gandhi was completely against partition. But they are today using that Gandhi was the one who brought about partition. So, it's just reading. You just go on reading whatever you like and it automatically develops.
I hope this encourages
Yeah.
I think we will take one more question. That young lady.
Hello, sir.
Introduce yourself, please. Introduce yourself.
I'm Sohini from Indian Express. So one thing that you've been stressing upon is how the citizens have paid. Now, in the past couple of, around a decade, we have seen that whenever citizens on an individual capacity have tried to raise their voice, they have been penalized or criminalized for that. So in such a situation, along with the fact that we are also seeing a revisionist history going on, including in school education, where you're deleting texts about Gujarat riots. So how do we then reconcile all this and move forward? I mean, the idea that you're talking about emphasizing on the constitutional framers' idea of what India was. How do we drive that in?
See, you don't need all these in textbooks. If you want to talk about Gujarat riots, we should also be discussing the 1984 riots. Minorities are dispensable at the hands of politicians. Keep that in mind. It doesn't matter whether you are a Christian, Sikh or a Muslim. If they think that they can get more power by, ill-treating them, they would not hesitate to do so. Nobody has ever questioned, the Congress leadership about what happened in 1984. And if Narendra Modi is accused of being responsible for 2002 riots, I have no doubt Rajiv Gandhi was equally responsible for 1984 riots. He didn't bring out the army within 2 hours or 1 hour. And he allowed every Congress leader to go on rampage. I argued the case against Sajan Kumar in Supreme Court when he was wanting bail. And I showed to the judges that in his constituency, more than 1,600 people were slaughtered. Now, as a member of parliament, did you not have responsibility to see that your people remain peaceful? So, let us, we don't need education about this. We must condemn everybody. We must condemn Gujarat, we must condemn Delhi riots. But we must, and we don't need that it is taught in the classrooms. The memory must be there. And, those memories should, and that comes only when you, read about them, what actually happened outside, outside the classrooms. I don't think, one thing that you must remember, and my friends here will tell you, unless we are prepared to make a sacrifice, nothing can be achieved. Nothing. I have suffered financially, hugely. They will tell you that. I have suffered socially. My own brothers, I have not been able to talk to them. My friends, many of my friends, good friends have ostracized me. So what? That's the price you pay for what you love to do, for what you believe. If you love your country, then I may be wrong. I'm not saying I'm right. But that's my inner conviction. And I speak with that inner conviction. And nothing can stop me. No amount of sacrifice is going to really come in my way. I have to be prepared. So I think, yes, the governments will use all kinds of measures. But that's how, always, liberties are preserved and protected by few individuals.
So I'm afraid my question to allow नहीं करूँगा, but before I formally request Salman Saab for a presidential concluding remark,
जो आपने बात कही, आई एम श्योर सलमान साहब उसका जवाब जरूर देंगे, what from the center we can do and we all can do। और जो आपने बात की तो जाहिर है कि ये जो कोशिश है हजरत साहब, ये जी जी जी, तो जो हंटिंगटन साहब का क्लैश ऑफ सिविलाइजेशन था, जिसके जवाब में प्रेसिडेंट खातामी केम विद द आइडिया ऑफ डायलॉग्स अमंग सिविलाइजेशन, तो हमने वही एक छोटी सी कोशिश उसी को आगे बढ़ाते हुए सेंटर के जरिए, इसीलिए इसका नाम ही रखा गया है IICC डायलॉग। तो दैट इज द वेरी आइडिया ऑफ स्टार्टिंग दिस इनिशिएटिव। तो हम जरूर करेंगे और जितना भी मशवरा आएगा उसमें सेंटर की तरफ से जो कुछ भी होगा, आई एम श्योर सेंटर विल डू दैट। आई एम नॉट इन द कैपेसिटी टू से एनीथिंग ऑन बिहाफ ऑफ द सेंटर, उसके लिए प्रेसिडेंट और ऑफिस बेरर हैं, मैं एक मेंबर हूँ, मैं कोई ऑफिस बेरर सेंटर का नहीं हूँ। लेकिन जो कुछ भी बेहतरी होगी, आई एम श्योर कि सलमान साहब इज थॉरो डेमोक्रेट, थॉरो इंटेलेक्चुअल हैं, तो वो जरूर आप सब लोगों की, बट इसके लिए सबसे जरूरी है कि हमारी जो कोई कोशिश है उसमें आपकी शमूलियत कितनी है। अगर आप इसी तरह से हमारे प्रोग्राम्स में आते रहेंगे, हमारी हिम्मत बढ़ती रहेगी, तो जाहिर है कि हम लोग भी आपके बिहाफ में सदर साहब से गुजारिश करेंगे कि हम कुछ और अच्छी चीजें करें। मैंने अपने इनिशियल रिमार्क्स में कहा था, जब फर्स्ट लेक्चर हुआ था, कि दिस प्लेस इज नोन फॉर गुड क्वालिटी मोगलाई फूड, बट वी वांट टू मेक इट ए फूड फॉर थॉट एज वेल। तो ये हमारी एक कोशिश है कि इस जगह को हम फूड फॉर थॉट भी बनाएं, but that won't, we will be succeeding unless and until you fully cooperate with us। आप यकीन जानिए, मैंने कम से कम 5000 लोगों को व्हाट्सएप पे दोबारा भेजा होगा, and after doing 5000 बार we could manage roughly 90 or 80, 100, but so happy that this hall is full, it's a capacity of 85 people। लेकिन 85 लोगों को बुलाने के लिए अगर मुझे 5000 लोगों को 5-5 बार व्हाट्सएप करना पड़ रहा, तो आप मेरा घर भी है, मेरी नौकरी भी है, बीवी भी एक है, 2 बच्चियां भी हैं, नौकरी भी, बॉस की भी गालियां सुननी पड़ती है, उसमें भी अगर मुझे 5000 बार व्हाट्सएप करना पड़ता है, तो खुदा के लिए प्लीज कम, प्लीज कम, प्लीज कम। सर आते ही पहला सवाल उन्होंने पूछा, यार कोई आएगा भी कि नहीं? कोई आएगा कि नहीं? तो एक प्रोग्राम कराना, हम लोग बहुत शुक्रगुजार हैं सदर साहब का कि उन्होंने ये जगह और चाय फराहम की हमें, लेकिन उस प्रोग्राम को करा लेना कितना मुश्किल काम है, वो हम जैसे ऑर्गेनाइजर से आप पूछें और शमामा जैसे। बट विद ड्यू रिस्पेक्ट सदर साहब, माइनर प्रेसिडेंशियल रिमार्क।
आपकी इजाजत हो से जो आप प्रोग्राम की बात कह रहे हैं, अगर रात का खाना होता तो प्रोग्राम और बेहतर लेकिन क्योंकि इतना ये बहुत कामयाब जलसा हुआ है, और क्योंकि तहजीब की बात आ गई और ज़बान की बात आ गई, तो अगर आप इजाज़त दें कि मैं अपना प्रेसिडेंशियल प्रेरोगेटिव इस्तेमाल करते हुए ज़ेड के फैज़ान साहब से कहूँगा कि आपका शुक्रिया। तहजीब, ये तहजीब का तकाजा है, तहजीब का तकाजा। आइए प्लीज़ 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 आइए। अब सदर ने कह दिया तो बस आ जाइए प्लीज़ आ जाइए।
जनाब सदर और ख़वातीन हज़रात, आई एम रियली फीलिंग ऑनर्ड कि सलमान साहब ने मुझसे ये शुक्रिया अदा करने के लिए कहा। यकीनन ये बहुत ही उम्दा लेक्चर दुष्यंत देव साहब ने दिया और हम लोग उससे काफ़ी मुस्तफ़ीद हुए, और सवाल और जवाब जो हुए उससे भी काफ़ी बातें समझ में आई। और जहाँ तक इकबाल साहब कह रहे थे, तो कि दुष्यंत देव साहब को तो खुद इस बात का इल्म है, वो जानते हैं कि आज के प्रोग्राम जब, इसीलिए उन्होंने पूछा था आपसे कि कुछ लोग में आएंगे भी कि नहीं आएंगे। तो ये दिल्ली है और दिल्ली में ये जो इंटेलेक्चुअल की इस तरह की मीट होती है, उसमें इस तरह के लोगों का भी आना वो बहुत बड़ी बात है। तो मैं इसको एक कामयाब लेक्चर समझता हूँ, और जो सिलसिला सेंटर ने शुरू किया है वो बड़ी बात है। हमारे कुछ दोस्त कह रहे थे कि सिलसिला शुरू होना चाहिए, ये सिलसिला शुरू होना चाहिए, तो सिलसिला शुरू होना नहीं चाहिए, बल्कि सिलसिला ऑलरेडी शुरू है। और हम लोग इस तरह के, बाहर बख्शी साहब में तशरीफ रखते हैं, वो तो पहले भी जब इस तरह के हालात नहीं थे तब भी उन्होंने बहुत सारे लेक्चर कराए हैं, और मुझसे उनकी बात हो रही थी तो बहुत सारे लेक्चर्स उनके माइंड में हैं इस तरह के प्रोग्राम करने के लिए। तो सेंटर इन चीज़ों को फैसिलिटेट कर रहा है, हमको उससे मुस्तफ़ीद होना चाहिए। और ये बहुत अच्छा लेक्चर हुआ, बहुत सारी बातें सामने आई हैं। मैं इसके लिए सेंटर को मुबारकबाद पेश करना चाहता हूं, बल्कि मैं तो कहूँगा सेंटर का शुक्रिया कि उन्होंने इस तरह का प्रोग्राम ऑर्गेनाइज किया। आप लोग तशरीफ़ लाए, आप हज़रात का बहुत बहुत शुक्रिया। और मैं उम्मीद करता हूँ कि जिस तरह का लेक्चर आज हुआ है और जो बातें सामने आई हैं, तो इसका जो एक मैसेज जाएगा, तो आइंदा जब प्रोग्राम होगा तो आपको 5000 नहीं 1000 भी मैसेज भेजेंगे, तो इस तरह के हाल भरा हुआ आपको मिलेगा। और हो सकता है कि अगर ये सिलसिला चलता रहा तो एक स्टेज ऐसे भी आ सकती है कि हमको फिर ऊपर मेन हाल में प्रोग्राम करना पड़ा। बहुत बहुत शुक्रिया आप हज़रात का कि आप यहाँ तशरीफ़ लाए।